and speaking to that motion.
Senator has the floor.
Thank you, Mr. President. So, ladies and gentlemen of the Senate, the bill you have in front of you is a bill about emergency orders, otherwise known as the red flag law. The substitute in front of you is a little bit different than the substitute that was passed by the Senate Judiciary Committee, and I'm going to walk you through some of the changes that have been made in the process. I know, first of all, there's been a lot of concerns about due process, and specifically, most of these changes, that's what that relates to. You don't see any of the changes to the floor substitute from the committee substitute until you get to page 15 on lines, starting around line 401. And first of all, I'd just like to thank our Lieutenant Governor, who had several concerns he raised about due process in the bill. And there were a couple of changes that he requested that we included in this. First of all, on line 404, we changed it from the original order. Originally, what the bill said the original petition had to be signed by either the Commonwealth Attorney or a Commonwealth Attorney or a law enforcement officer. A Lieutenant Governor suggested he thought, in order to ensure proper due process and a thorough investigation, that it be signed by 2 law enforcement officers. So that addition was made on line 404. Additionally, another change that the Lieutenant Governor suggested was on line 412 to 413, which is that one of the findings a magistrate has to make before ordering an emergency risk order and surrender of the firearms is that they have to make a finding as to whether or not any reasonable alternative exists in connection with the process. Some other changes that were made during the committee process, the biggest one is on between lines 420 and 429 between the committee and the floor. If you all remember, the original bill that came out of the Judiciary Committee said that when an emergency order is issued, a search warrant is also issued with the order, and that search warrant would be served at the same time the order is. And so you would have the police not only going to somebody's house to give them one of these emergency risk orders, but they would also be giving them a search warrant and have authority to go into their home and retrieve the guns all at the exact same time. And because it would be a search warrant, that would also give them the authority to go into their house and poke around and go into virtually any type of compartment where you could have a gun. Senator Morrissey had a healthy conversation with our caucus about his concerns about that. And in light of his concerns and some concerns of some other people, we removed the requirement that the search warrant be issued at the time the original order is entered. And now what happens is the emergency risk order is taken, the magistrate issues the order, law enforcement takes it to the person's house, they hand it to that person, and they advise them of the time that they need to surrender their firearms. If the person refuses to surrender their firearms, or if there's probable cause to believe they continue to possess firearms at that point, then because an emergency risk order is entered and it's a crime to possess a gun, if one of these orders is entered and you're on notice of it, a law enforcement officer would then have probable cause to go seek a search warrant at that time because you'd be violating the law. And so the search warrant language is all completely out of the bill now, but there is a sentence making it clear that this doesn't prohibit the issuance of a search warrant, just so the code's clear. So the idea there is that it will sort of de-escalate these situations a little more because you won't have somebody showing up completely unannounced, knocking on the door, seeking the guns without any kind of notice whatsoever. So that was the biggest change that was made. Just above that, in lines 418 to 419, it makes clear the law enforcement officer has to advise the person that they need to voluntarily relinquish the firearm. There's also a requirement that I requested in committee, which is included on line 439, that when the person is given the original order, they have to be given an affidavit showing the allegations being made against them so they know what they're being accused of, which will assist in them being able to prepare their defense at the 14-day hearing that subsequently occurs. There's also another due process provision that was put in at my request, making it clear that these proceedings are civil and not criminal. Additionally, that discovery is authorized, that is, you could issue subpoenas or issue discovery to test or find out the allegations being made against you before you're required to go to trial, so that you have a full chance to litigate your matter in front of a judge without being ambushed. That was included in my request. In addition to that, there was also a provision put in to make this consistent with domestic protective orders, where the person accused in the order has the right to seek a continuance of the order if they feel like 14 days is enough time to prepare a defense. And as a practicing attorney who's had to both prosecute and defend protective orders, I'll tell the body 14 days is often not enough time to get ready for a hearing at the last second. Often it takes time people to find a lawyer, then it takes time to find money to hire the lawyer, and then it takes time for the lawyer to find out what happened. And so it's important that if people want to be able to fully defend themselves and to defend their constitutional right as they see it, that they have an opportunity to prepare their defense, because there is no appeal from this de novo like there are with regular protective orders. These proceedings will be in a circuit court, and your only appeal will be to the Court of Appeals of the Supreme Court, actually to the Supreme Court, I guess. So it's important that these matters, that the people have a full opportunity to investigate these matters. So those are some of the changes that were made. If anybody has any questions about the substitute, I'm happy to answer any questions about the substitute. There's also an amendment proposed by the senator from James City County, which I don't think has any issues with it. And additionally, there's another floor amendment that I'm offering to the substitute, which makes it clear that there needs to be an affidavit attached to the original petition that's filed. That language got deleted by accident in the substitute. We need to stick it back in so that these matters are sworn under oath, so that if somebody tries to abuse the process and lie, they will be subject to a perjury prosecution, and that they are really put on notice that they're swearing under oath when they do these things, and they don't take it lightly. So that's the substitute. I'm happy to take any questions, and again, renew my motion that we pass the substitute.
Thank the senator. For what purpose is the senator from King George, Senator Stewart, rise?
Speak to the motion, Mr.
Senator has the floor.
Thank you, Mr. President. Members of the body, I've read these bills and I've talked to many of my colleagues on the other side, and I really appreciate the fact that folks are trying to make an effort to make this better. I really do, because I know that each and every one who's had a hand in this is a good person, and they're trying to accomplish a good thing. But let me tell you, this bill, out of every bill that I have seen since I've been in the General Assembly, and I've been here for 12 years, scares the hell out of me. And everybody should think about it. Think about the ramifications of it and what it could be used for. You know, of course, we want to get guns out of the hands of mentally ill people or people that may commit harm to others. We all agree on that. But the devil's in the details. And there are a lot of devilish details in here. And my friend from Eastern Fairfax talks about due process. Due process went out that window somewhere. There is no due process in this bill. The reason being is because you can get an ex parte hearing through a magistrate, not a circuit court judge, but a magistrate. The law enforcement officers can go to that magistrate, they can get this substantial risk order, and then they can go to this person's home and try to serve it. And yes, you don't get the search warrant at the same time. Now we're going to make these people a criminal. We're going to make them a criminal and say you violated a judge's order in order to go back and execute a search warrant. We've actually made it worse, I think. In some respects, there's a strong argument that we've made it worse. You know, I respect law enforcement as much as anybody up here or more, because I practiced in that field as a Commonwealth's attorney. And I have personally witnessed officers who, with all their heart and soul, believed they were doing the right thing, and they believed somebody was guilty, but they didn't have any evidence, and they were going to try to get that evidence any way they could because they thought they were doing the right thing for the community, and they believed that they were doing the right thing. My gosh, have we given them a tool now? Because all they have to do is go to that magistrate and get that order, and then go serve that order, and then walk away and say, well, I'm confident there were guns in there. I have information that there were guns in there. Shoot, I saw a gun behind a curtain in the other room, but I couldn't get to it. I couldn't enter the house because I didn't have it. And they get that search warrant. Everything they find in that home is now subject to whatever they want to do. And the ability for mischief, I can't even begin to explain on the floor malicious purposes that this could be used for. Why don't we talk about a process where if someone is so mentally disturbed that we need to get their guns away from them, we probably need to get them help too. So why don't we bring those folks before a circuit court judge and let that person have a lawyer, either one they want to hire or the court appoint one for them if they can't afford one, and let the judge hear the case between whoever the petitioning party is and the person that we want to impose a substantial risk order. Let them have their day in court. Let them confront their accusers. Let them present witnesses on their behalf. Imagine that. All of the things that our Constitution guarantees each and every one of us. When we throw away due process in this example, we are creating one of the most grave injustices on the citizens of Virginia, and each and every one of us should be afraid of this passing, afraid of the things that it could be used for. You cannot look past all of the bad things, the malicious things that a bill could be used for in trying to catch up a few people, because I'm telling you, you will ruin hundreds of lives in Virginia in the time that it takes to fix this. And I'm not making this up. Think through it. Give these people their day in court with representation. Let the judge decide if this person is a danger to himself or society. Typically we do that in many other cases. And why do we want to leave somebody? Why do we just want to take their guns? Why don't we want to help this person? If they're not going to use a gun to hurt somebody, my God, there are a million other things they could use to hurt people. So why don't we bring this person before the court? Why don't we let them have their day in court and let this judge make a determination and then go from there the legal way, the constitutional way, the American way. I mean, that's the way we do things. We don't surreptitiously do things the way this bill proposes and then we serve it at 3 a.m. in the morning. As the sheriff testified in the Courts of Justice Committee, you vote for this bill the way it is, you're going to be signing people's death warrants. And he's right. There's a better way to do this. And I know it's going to get done this year. I understand it. But please, let's roll it back. And if you're going to get it done, let's do it right so it doesn't at least harm Virginians. I hope we'll vote against this.
Thank the Senator. For what purpose is the senior senator from Chesterfield, Senator Chase Rise?
Thank you, Mr. President. I rise to ask 3 questions from the senator from Eastern Fairfax County.
Senator Rise for a question.
I'll yield.
Senator Yield, you have the floor.
Thank you, Mr. President. Is it possible for an innocent person to have a weapon taken from them before proven guilty during the 14-day waiting period?
Senator has the floor.
Mr. President, I would say that I don't fully understand the question. My question would be to the senator from senior senator from Chesterfield: is the innocent of what? I'm not sure what crime.
Senator want to?
Yes, thank you. I'll be happy to clarify. My question is this: during the 14-day period from when a person is arrested and before they go before a judge for a possible crime to have their weapon taken from them, is it possible for an innocent person to have a weapon taken from them before they are proven guilty, denying them of due process?
Senator has the floor.
I'll yield. And thank you, Mr. President. What I would say to the gentlewoman is, first of all, nobody's convicted of anything with this bill. This is a person who is found to present a substantial risk by a magistrate after presentation by a law enforcement officer or a Commonwealth attorney that they present a substantial risk. So nobody is convicted at the beginning. They're just the subject of a emergency risk order, number one. Number two, the person is advised at the time they're served with the order and by the order itself that they are required to surrender their firearms. If they surrendered their firearms, then they're not committing any crime. If they continue to possess a firearm after the order is issued, they could be charged with a crime of illegally possessing a firearm in violation of this new code section, which I believe is on lines 91 through 100. And in order to prove possession, you have to show that an item is subject to someone's dominion and control, they're aware of its presence, and they're aware of what it is. And so there are a whole series of things you have to show in order to prove possession of a firearm. You can't prove possession just because it's in someone's home. There's a whole series of cases about, or in their car. There's a whole series of cases that talk about what you have to do to prove actual possession of something. So it's kind of a long answer, but it's a complicated answer to your question.
Further question?
Yes, thank you, Mr. President. I do have a couple of other questions. Is it your understanding?
I'll yield.
Is it your understanding that with a permanent restraining order, whenever that is issued, that a person automatically gives up their guns under a permanent or emergency restraining order?
Senator has the floor.
Thank you, Mr. President. What I would say that the senior senator from Chesterfield is that I think what she's talking about is a protective order for domestic violence, of which there are three different kinds. There's an emergency protective order, a preliminary protective order, and a permanent protective order. We don't have restraining orders in Virginia, although people call them protective orders. I think that's what she's talking about. And I would say to the senator that with regard to preliminary and permanent protective orders, there's a requirement in the code that no one is allowed to possess a firearm if they are subject to one of those. They do not surrender them to the government. However, they can. I think there's actually a provision where they can surrender them to the government for safekeeping, but they're not required to. They're allowed to give them to somebody else, just get them out of their possession, which is what I talked about a minute ago. They can't be, subject to they know it's there and on their body or something they can touch.
Further question?
Thank you. One final question.
Senator yield?
I'll yield.
You have the floor.
Thank you, Mr. President, and thank you for your patience. My final question is, this provision, does this create a government-run registry?
Senator has the floor.
What I would say is not really. I mean, anytime a legal proceeding is filed against somebody, it creates a record of the proceeding. There's nothing about these proceedings that are sealed. And so if somebody were to go to the circuit court and search for someone's name, or go on the Supreme Court's website and search for their name, it would show up that one of these proceedings was initiated against them. But there's no, and I'm sorry, also, if one of these orders is entered, I believe VSIN is notified. That's the Virginia Criminal Information Network maintained by the state police. And so there'd be a notation on your criminal history, at least while the order's in effect. And I'm not sure about after it's gone, but I think there would be that showing. But this would not create any kind of gun registry or registry of bad people or anything like that.
Further question?
No further questions. Mr. President, to speak, unfortunately, against this bill for the gentleman who I have a lot of respect for, but we disagree on this particular issue, Mr. President. My concern with this bill, Mr. President, and I agree with and identify my comments with the senator from King George. My current concern being the lack of due process with this bill. The government and one or two people can identify someone as a substantial risk without much due process. And I'm concerned that we are, in fact, creating a registry. And for that purpose, Mr. President, I think this is a dangerous bill and one that I will not be supporting today. Thank you.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey?
Thank you, Mr. President. Mr. President, I rise to speak in support of the floor amendment offered by the senator from Fairfax.
Senator has the floor.
I've listened carefully to the dialogue between the folks on the other side and Senator Serville, and to some degree, I think they're speaking over one another, and I say that respectfully. First of all, the concerns from the senator from Prince George dealing with an ex parte hearing, the possibility of mischief, doing away with due process, are legitimate but not applicable here, and here is why. If you look at the gist of the changes to the bill as offered in the committee, you'll look at line 15, and the senator from Prince George talked about an ex parte emergency substantial risk order on line 408. It is an ex parte order. But here's the thing. Every arrest warrant, every search warrant, every TDO is also ex parte. There is always the possibility of mischief. If I was desirous of creating mischief and wanted the senator from James City County arrested, I can go to a magistrate, swear out an oath, raise my hand to God and say that he assaulted me. It is ex parte. They are not going to call Senator Norman up and say, give me your version. When you go to get an arrest warrant, the police officer is going to go to that magistrate, and he is going to speak to that magistrate, and he is going to get a search warrant ex parte. The magistrate is not going to call up the object of that search, that individual, and say, give me your version, and the same with the TDO. So first of all, it's all done ex parte. What occurred at the committee was the following. Yes, the sheriff spoke, and he talked about coming in the dark hours of the night, but at that time, what was inserted and was part of the bill was the following. When an individual went, or a law enforcement officer or a Commonwealth's attorney went down to get this ex parte order, simultaneous to that, he would get a search warrant. So then he would then go hand in hand and go at 3 a.m. or 7 a.m., knock on the door and say, here's the substantial risk order, and oh, by the way, here's a search warrant. The concerns by my friends on the other side were legitimate, they were justified, and they've been addressed. As Senator Servill said, all of that language dealing with that search warrant have been removed. This is actually a TDO, a temporary detention order light. In a TDO, you get it ex parte, you go there, and you pick the person up, and you take them to a facility where they can get treatment. Here, you serve the substantial risk order on them and say, do you have any weapons? If the individual says, I do, and voluntarily relinquishes, it's over. If the individual says, I don't have any weapons, even though the affidavit supporting that special risk order said that the individual had weapons, the officers leave. They cannot go into the house. It's only afterwards, if a family member or a friend or an office worker says, you just served them the order yesterday or last night, they're down in the bedroom, they're cleaning out their weapon, and they're muttering about how they're going to kill people, then you can get that search warrant. So I think with removing all of the language regarding the search warrant, it should assuage your concern. But let me tell you this, there's always going to be room for mischief. If you look to page 16, look at line 439. Senator Servill mentioned that the order is served with a supporting affidavit. Here's what will happen. When you get that order, that substantial risk order, you're going to get an affidavit, and it's going to say, so-and-so said the following. You're going to read those reasons why the magistrate issued it. And if it's mischief that's amok, you're going to say, my goodness, look at this supporting affidavit. It's completely false. And you will have your opportunity to address that. Senator Servill took a great caution to say that make sure that there was time to get a hearing. And then when you get that hearing, you'll go before then, you'll have your attorney. That's the first thing. The other thing is a couple of days ago, there were some concerns from the other side. My friend Senator Stanley from Franklin County talked about in regard to Senate Bill 35. He said this bill doesn't protect an individual or people. This bill does protect individuals. It protects the individual who is the subject of this emergency order. It also protects those individuals who could be the recipient of some type of carnage. Also, Senator Stanley said that he was concerned that it expands government. By taking out the language of the search warrant, we are limiting government. We are limiting government. My colleague from James City County, Senator Norman, responded once by telling Senator Servill in the other bill, if you stop trampling on constitutional rights, I'll round you up some votes. This bill, in this iteration, does not trample on the Fourth Amendment rights. It protects against an unreasonable search and seizure. I'm hoping Senator Norman rounds up some support for this bill. I would love to address if there's any concerns from the senator from Prince George about lack of due process, the trampling of rights, because I really believe at the end of the day, what you have here with this bill is a TDO light, and then the opportunity, if we find guns later on, to go and get a search warrant. And don't forget, at the end of the day, you still get that hearing. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Rockingham, Senator Obenshain, rise?
Mr. President, I would ask if the senator from Eastern Fairfax would rise for a question.
Will Senator yield?
I will yield for a question about the substitute.
Senator yields. You have the floor.
Lucky for him, my question is about the substitute. Maybe a couple of questions. First of all, my question relates to a different right, and that is the right to privacy. Mr. President, I would ask the gentleman, I assume that a petition would include, by necessity, some of the details relating to the concerns about the threat to safety posed by the individual to himself or to others.
Senator has the floor.
I would say to the gentleman a couple things. Number one, I'm ecstatic that he believes in the right to privacy, which is, of course, not specifically stated in the Constitution, but is the foundation for the right to reproductive choice and contraception. But,
I thought we were talking about this bill.
In any event,
Proceed.
Having said that, yes, I would say to the gentleman, first of all, there would need to be an affidavit which would need to detail the factual allegations that underlie the basis for the request. And as I mentioned in my initial remarks, the language about the affidavit got inadvertently deleted, and I have a floor amendment to stick that back in, which we haven't considered yet. But I think the answer is yes.
Further question?
Mr. President, further question.
I'll yield.
Senator yields. You have the floor.
Mr. President, my further question also relates to privacy, which I would point out is a right that is often conferred by statute. And we have statutes like HIPAA and other statutes, our state companion to HIPAA, that provides for important protections for privacy with respect to our personal medical information about mental health issues and others. And my question is, if a process under this statute is pursued and the petition and accompanying affidavit contain information about the mental health concerns of the subject of the petition, and an order is issued, is there any protection for the subject of that petition or that order that would provide for any protection of their confidential medical information, given that this is a civil process?
Senator has the floor.
I would say to the gentleman, no, there's not, and there similarly is not when somebody signs an affidavit for a domestic violence type protective order, the three I described earlier, or people can put all kinds of stuff about your medical history and legal pleadings and do every day that people can go down to the courthouse and read. So there's nothing particularly unusual about that.
Mr. President, further question.
Senator
I'll yield.
And,
you have the floor.
And my questions do relate to this substitute, not processes that are already available, given that we are creating a new avenue for the dissemination of personal, confidential medical information. My question would be that in the event that a petition is found to be unfounded, my understanding is that the way this would work is that the court would dissolve any preliminary order, or it would expire or be dissolved. And my question would be, in the event that it is dissolved, is there anything that would provide protections for the person who may have been falsely or whether through negligence, gross negligence, or intentionally falsely accused of
committing behavior or somehow posing a risk to the safety of him or herself or to another, is there anything that protects them other than the provision in here for a cause of action for intentional and deliberate misleading and false information?
Senator has the floor.
I would say to the gentleman a couple different things. First of all, any type of medical information for which a person has an expectation of privacy under HIPAA that their doctor has or some medical professional has, law enforcement and the Commonwealth Attorney would not be privy to that because there's no process by which they could obtain that information from the person's doctor or medical professionals in advance of the issuance of these. And so any information that they might have would be information either gleaned from a family member or from the public record. And so the person would have relinquished their right to privacy about that information if it were to be contained in this document. So just preface it with that. But secondarily, there's no provision in here, nor is there an existing Virginia law that would allow an expungement of this type of process. Currently in Virginia, we only authorize expungements for criminal proceedings, criminal charges, to some extent civil charges, depending on which judge you have. But there's no way to delete these things once they're out there, just as is the case with civil protective orders in the domestic violence realm. There is, of course, the ability to sue somebody, which I think the gentleman hinted at earlier, for abusive process, which is a civil proceeding, which typically requires a showing of malice or intentionality. And there's, of course, the ability to charge somebody with either perjury, if they sign something under oath falsely, or filing a false police report, which, given that this requires a law enforcement investigation, I think would fit within that statute as well.
Further question?
Thank you. I thank the gentleman.
Thank the senator. For what purpose is the senator from Hanover, Senator McDougald, rise?
Thank you, Mr. President. Mr. President, I rise to speak to the amendment.
Thank the senator. You have the floor.
Mr. President, I think we're all talking past each other a little bit more than maybe we should. I think this is much more basic what this amendment does. Mr. President, in our system, we say for the government to go get a search warrant, you have to have committed a crime, alleged to commit a crime, or somebody has to have alleged to commit a crime. Mr. President, we are turning that process on its head. Mr. President, this is a process now where the government goes before or without